order in this of the thereof, member ceases to be publicly resign and or publicly declare on the as a result, one, Mr. Yusuf on the DA's Federal Legal Commission responded to this demand by cessation clause was of application, which he claimed pertained only to resign as name. She further stated that to determine that the membership at sea for member, the chairperson of the Federal Legal Commission, the FLC, on the when it offers through the prism in its own to terminate Mr. Meyer was dependent, which he volunteered, was to ensure that its view that on an objective view, a reasonable intention to resign from the party, resign from the by operation of the FLC and FedEx. In that they constitute resign from the party, from the mayoralty. It is only that the further lines in such circumstances could be considered. They just our learner clearly also understood her of an intention to resign from party. Even if we were minded, and were also of the view, did not necessarily follow that. In this regard, it was not unequivocal, clearing a name, a purposive that the clause in response, counsel for the expressed intention was nonetheless was clear intention to resign. Put simply, an intent committed by the rules, then they can that membership has ceased. Duly appointed the chair and deputy chair of the FLC. The party's federal leader was not present, and the FedEx took the role of recommending all of the 20 principal for appointment by the federal constitution is a different granted by the Council on 25th to 26th July 2015. It appears that the chairperson of the FLC and the 9 provincial leaders were not included as appointment. According to the DA, that the selection panel, principal members, and 10 they did not form part of the FLC. To be read of the FLC, and its task was to recommend an alternate. The DA said that in way and 2011, however, it was also 10 members and the additional different and another group of up to 20 members plus alternates would constitute. The original 11 members of the selection to serve only to identify did not themselves ever serve. We found the differing instances which afforded to the clause be no ordinary meeting chairperson FedEx was required to as possible preferably would form a selection and FedEx was required to make recommendations to the Federal Council of the FLC comprising up to a dean of qualified persons. Importance on the issues they were to decide upon. It is abundantly clear that on the DA's own version, clause 11.1.1 was material, not properly constituted. Appears that the 11 members of the selection panel were not considered In our view, LC panel, which was appointed to make a determination in respect of the alleged cessation of effect conceded by the DA's Council within the context of the DA's constitution and body politic is an important structure and has wide powers. The composition of the FLC must accordingly be within the four corners of the federal constitution. This is in line with the principle of legality. A failure to do so certainly falls outside the boundaries of the federal constitution. The non-compliance of the said clause, having regard to the purpose of it, was material and properly evaluated, brings about an irregularity that justifies a ground for review. But there is, in our view, a further material reason why the decisions in questions are reviewable. As we have previously pointed out, the DA's constitution further put in the event of a case of cessation, and assuming Mr. Lille did publicly declare that he intended to resign from the party, to be of the FLC. Chapter 10 of the DA's FLC must determine the rules of procedure which may be applicable to it, which may not be in conflict with the federal constitution. The procedures that are 10.5 of the federal constitution. Clause 10.5.1 provides as follows, and I quote, "The rules must apply to all proceedings of a panel, provided that the rules are adverse finding against 1.1.1, person has been sufficiently informed, every allegation and evidence of. It's apparent from these peremptory adverse finding against Mr. Lille, mitigation, which in our view, the party 5.1. A further material irregularity that was arrived at, namely that Mr. Lille's membership had ceased to exist. For these reasons, it follows that the relief sought in paragraph 3.1 of the amended notice of motion part B must succeed with costs, including the costs that stood over in relation to the application for interim relief in part A. In the result, the following orders made. The determination by the first respondent that the applicant has ceased to be a member of the DA in terms of clause 3.5.1.2 of its federal constitution is declared to be unlawful and invalid and is reviewed and set aside with costs. Such costs shall include the cost pertaining to the application for the interim relief in terms of part A and the costs of the employment of two counsel.
I agree.
I agree.
It is so ordered. Court will adjourn.
So we'll get the response in this country.
You're going to do this, dude. You got the mic. Well, get it to me quickly.
Yes, you may.
Ja, zeg maar zo maar morgen.
Dit is môre. Môre. Steen is in report.
They are peeling the...
Rodney Lenton. Rodney Lenton.
I'll be speaking to Alex.
Lenton. L-E-N-T-I-T. L-E-N. T-I-T.
Thank you.
This is got the big one. And the second part of the mitigating circumstances. I mean, that obviously has got a huge impact as well for the way that they apply those independent cessation clauses. Because I mean, they want to get rid of people in 24 months and they can't do that.
When is the pass?
After tomorrow.
Hier wo sein Bikini da so.
Viva!
And you coming for you?
Viva de la Viva!
What?
And then
Jason?
can you go closer? Slightly sideways, no?
Okay.
Wacht op Jason nou zo.
Nee, ons kan nie vir Jason wegneem.
Yeah, no.
Jason, we're starting. Ja.
Let me.
Die gaan nog niet uit.
Let me start with the thank yous. I want to thank the people of Cape Town. I want to thank my legal team. This victory is not just a victory for me, it's a victory for the people of Cape Town. Because I can go back now and I'm energized more than ever before to go back and to continue to serve the poor, the marginalized, and the most vulnerable in our city. Indeed, this judgment has got far-reaching effects. The whole Federal Legal Commission of the DA has been declared invalid, and together with that, all decisions that they've taken, including all the disciplinary hearings and attempts to discipline me, they have to start from the beginning. They have to re-elect a FLC, they have to reappoint new members to the Federal Legal Commission, and I still insist, after they've done all of this, because all decisions of the previous FLC is now null and void, that if they repeat and correct all their mistakes, and I am still prepared to subject myself to an open disciplinary hearing in front of the public and in front of the media. But this victory today also sends out a very strong message that we have rights in this country, and that we've got rights in our Constitution, and that no one is above the law and no one is above the Constitution of this country. And as all political parties, we must learn from this lesson to treat our members with respect. Because even up till today, I'm back in this court again tomorrow. Because I've been fighting for a fair process and a due process. That's what my fight has been all along. Tomorrow I'm back in this court because all of these allegations that they continue, these untested allegations that they continue to put up there in the public, they have refused to give us the evidence of that allegations. So tomorrow again, the court must now rule and force them to give us the evidence. What kind of justice is that? But it's when people who are not used to for justice, we fought for justice in this country. Many of them don't understand the word justice. They claim to be constitutionalists, but thank God we've got an independent judiciary that will protect the rights of all South Africans, including the rights of Patricia de Lille that they've been trying to violate. But this is not the end. I will continue to fight for fairness and justice for all the people of South Africa. Thank you.
They made a summary of Afrikaans and the outcome of the court.
Afrikaans?
Afrikaans, yes.
So, sorry?
Yes.
Viva! Viva!